All right, this is class 5 for Music Biz and Law. The date is April 20th, 2020. All right, few housekeeping details before we get started here. Remember your research paper, 1,250 words, this is going to be about 5 pages, but I'm not interested in pages, I'm interested in words. So 1,250 words, must have at least 3 sources, and you're going to end up with a 10-minute presentation. Your topic should be finalized by now. It's important if I've given you some caveats on the topic that if I ask you to check with other people, make sure that you're not duplicating each other's efforts. Um, Make sure you follow through with that. These presentations will be part of the class, the last class. On the last day, I'm going to have you post your presentations to your Google Drive accounts and then link that, share it with everyone so we can watch your presentations. It's important that you don't, there's 4 people in the class. I don't want you all covering the same things so that that would be redundant and boring. So make sure that you are following through with that. Your outline and sources were due last night. Your rough draft is due next Sunday evening. Be sure, I will check the papers for plagiarism. I will take sections of your paper and run it through Google, and we have a plagiarism checker now and Canvas. So make sure that you do not plagiarize. Plagiarizing happens if you copy something out of off an article, which is very easy to do. It's easy to plagiarize, and you don't want to do that. That's grounds for certainly failing the paper and probably failing the class. So it's better to hand in nothing than it is to plagiarize. So don't plagiarize. I'm sure none of you will do that, but I'm just saying. Especially as we talk about copyright today. So plagiarism happens if you copy something um, and you don't put quotes around it and you don't cite it. Also, if you copy an idea and you don't cite that. So if you're taking information from an article, even if you aren't quoting it exactly, if you're taking an idea from an article, it must be cited. CITED. It must be cited. And we're using Turabian in the music department, so make sure you're using Turabian in terms of your citations in your paper form, and everything will be fine. So presentations, 10 minutes long. Like I say, prepare those. Get all of that to me Sunday, the May 3rd. Of course, your rough draft of your papers due next Sunday. On the 26th. But your final paper and presentation are due the night before the last class for this class so that we can have it ready for regular class time. Um, okay. This week we're going to cover the rest of pages 211 through 342. Talk a little bit about executive summaries and get into some finer details of some of the things that we've been talking about in terms of copyright. The following week, next week, okay, so this would be for the class, the 27th, a week from today. This is Monday, the 20th. So for the 27th, you should read pages 343 through 400. That's on group issues in touring, page 343 to 400, group issues in touring. As I say, your rough draft is due next Sunday. And that pretty much covers that. All right. We'll talk about executive summaries here in a moment. First of all, I want to start with a question from Martine. Martine says, we've been studying a lot about percentages lately, learning who gets what slice of the musical business pie, but I'm still confused on exactly how much of the pie there is to start with. I want to give you an example of how complex this gets. This is page 303 in the book. And it says, they give an example. They say, let's say you're a rapper. We're going to cover some of these things today in terms of co-writing a song, being the songwriter, being the artist, being the, I mean, all those are different entities in terms of being paid, even though you may be the same person. Who's the publisher? Are you the publisher? Do you have your own publishing company? Um, so it says, here's a rapper who's signed to Universal Publishing as a songwriter. So pretend you're the rapper. You're the featured artist on the master with JJ, a producer. JJ used a track created by Bull, who signed to Warner Music as a songwriter. Bull's track had two master samples he borrowed from James Brown. The Squirrel Brothers, who are two writers signed to Cobalt Publishing, wrote the lyrics. You and your producer JJ wrote the top line melody. At the last minute, Kendrick Lamar came in to write and perform a guest rap, and you give your record to Republic Records and it's blowing up. Each time the track is streamed, downloaded, or sold, who gets paid? So the answers to that, for the master track, you get paid, Kendrick, JJ, the producer, possibly Bull if he didn't sell his track outright, the label that owns James Brown's masters for the sample, and then SAG, AFTRA, the unions, which we haven't covered yet. The folks who get paid for the song, because the song is different than the recording, your publisher, which is Universal, JJ's publisher, which is Sony, Bull's publisher, which is Warner Music, Squirrel Brothers publishers, which is Cobalt, Kendrick's publisher, James Brown publisher for the sample. So by the time we're all done there, that one song would, you'd be splitting stuff amongst 11, maybe 12 parties. And that's the way the industry works. This is not an unusual situation. So Taylor Swift, because we're talking about Taylor Swift, we talked about her in the past. Taylor Swift might write a song and perform the song, and her writing, perhaps her writing is through her own publishing company, but the recording is done through a record company. There are producers, there are people who might co-write with her. Um, there are all sorts of people in the food chain who get paid. So it's very complex. Now, back to Martine's question. From what I understand, so he's still talking about what percentage of the pie do I actually get if I write this song. He said, from what I understand, say a physical CD of a 5-song extended play sells for $5. I shell out the dough to have them printed after I recorded them in the studio. I own the phono recording, the copyright, and the physical copies. Absolutely. Martine owns everything at this point. I sell it for $5 to Joe. I pay my taxes, and the rest is mine, right? Yes, the rest is Martine's. Because Martine never signed the rights over to any of his songs. He didn't hire a publisher. He didn't hire a record company. Those are two different animals. And he doesn't have a band. He hasn't shared the ownership of that song with another writer, and he hasn't shared the rights to the recording and the rights from the EP with the band members, other performers. So all the money is going to flow to Martine. Martine's going to spend the money to make the CD. He's going to spend the money to distribute the CD. He owns all aspects of the recording. He gets all of the money. He gets all the bills. So once all the bills are paid for, whatever's left is yours to keep. So in this case, your only partner are the people that you're hiring to produce the CD and Uncle Sam, who you have to pay taxes to. It's still a substantial amount of money that you give away to other people, but the point is that you have complete control. He goes on to say I take that same EP and somehow get it played on Spotify, iMusic, and Amazon. I'm still a little confused about how that comes to pass, but say it happens. Now, every time one song is downloaded, I get my dollar minus the middleman's cut, right? How much do they take? And every time my EP is downloaded, I get $5 minus their cut. and every 15,000 streams, I get $5 minus their cut, right? Am I understanding this correctly? Okay, now remember that Spotify, iMusic, and Amazon are streaming services. You are not, since you aren't using um, uh, any kind of go-between to handle the streaming. You aren't using Harry Fox to collect royalties from whoever that's using the song. You aren't using BMI, CSAC, or ASCAP for the performing rights. I mean, none of that is because there's none of this. You haven't hired a publisher and you haven't hired a record company. You own all the rights. So when you send something to Spotify, iMusic, and Amazon, you enter into basically a contractual agreement with them directly. And whatever they decide, whatever they say to you, they don't have any rights to your recording. You're simply posting that recording on their site, and they are going to give you money based on how many times that recording is played. Whatever their contract is, and I can tell you from personally, from working with YouTube and doing YouTube videos, producing content for YouTube, and allowing the YouTube algorithms to do what they do. Music dollars generated from streaming services. Now, YouTube is a video service, but dollars generated from streaming services can change. So whatever it is, when you post your music on these services, you're entering in basically into a contract, not with them. You're not giving away your copyright, and you're not giving away your content. You're allowing them to take your content and stream it to other people, and they're going to pay you money for doing that. So it's whatever you set up with them. You don't have to share that revenue. Um, they're making revenue off of your income streams, but you don't. Uh, they're getting their revenue directly from advertisers, and they're paying you out of that revenue. So you aren't going to make a lot of money with those types of businesses, with those types of models. The reason you would do a Spotify, iMusic, and an Amazon is to have your music. It helps you market your music to your potential audience. So even though you're not going to get wealthy, um, you do get exposure. And if you aren't going with a music publisher and with a record company, then you're uh, you have to you're doing it all yourself. You have to find outlets for your music. Um, we've talked about this in the past, and it's worth bringing up now. If you are a creator, if you do artistic creation, in this case music, let's stick with music. You can create your music and keep 100% of what you do by not contracting with anybody else, by not getting rid of your copyright or assigning your copyright to someone else, or allowing Harry Fox to collect fees, or whatever it is that you're doing to get your music out there. Understand though that the reason you go with a record company and the reason you go with a publisher ultimately is because of their vast resources and connections and their ability to market your work. Um, the, uh, the the playing field has changed. So if you are on top of your game and you do the kinds of social media marketing things that we talked about in the previous Music 310, um, if you do that, you have a chance to enter some of those same markets. The more you sell, the more clout you have in negotiations. If you do it yourself, in a certain sense, you're going to have to become somewhat of an expert in terms of marketing, and you're going to have to become an expert in terms of the legal side of things. These two classes, the marketing classes, the marketing class and the music business and law class, tell you just about everything you need to know in the grand scheme of things in terms of record deals and publishing deals. Those are two different things. But it, uh, but you must understand the business as you get into it, so that you don't end up signing something that gets you into trouble. At the beginning here, Spotify, iMusic, and Amazon, if you're self-promoting, those are going to be important places to to place your music, and you're going to get paid for people playing your music. You're not going to get paid a whole lot, but you will get paid. The places where you, and we talked about this again in marketing class, the places you're going to make your income is by getting fees from concerts, uh, money from offerings in churches, if you're doing Christian music, merchandise sales. Um, if you write a great song, you might sell that song to a publisher, get some money there. Those are the ways you're going to make a living. And In terms of the huge record deals, the record deals are there really, uh, if you get a huge record deal, you may choose to take that, and then that's when you need an attorney. Otherwise, your live performances are probably going to be where and then CD sales and live performances. That's probably where you're going to get the majority of your revenue as a working performing musician. So Christian musician is going to work the same way as a secular musician. It's just the venues are different. So keep that in mind as we talk about this. There's the do-it-yourself way. That was basically the social media marketing way, and then there's the uh, go big or go home way, which people would say, I don't think you have to do that. I think you can do it yourself. But if you do get an offer on a record contract or a publishing deal, that's where you need an attorney, and that's where all much of what we're talking about here kicks in. All right. If you have more questions about that, email me your questions and I'll try to discuss them in the next video. Executive summary. With the executive, you're writing an executive summary for this assignment this week. An executive summary is not an abstract. It's not a preface to your business plan. It's not a digested version. What an executive summary is, well, maybe a digested version is a digest is pretty close to it. What you're telling the reader is your mission statement, your product, your service, your financial situation, what you plan to do, what success looks like, and you're giving them a reason to invest money in your business. Executive summaries often, usually, are the only things that people read when they read your executive plan, your business plan. There will be people who, if they're intrigued by what you're doing, will go through and pick your whole business plan apart and look at the fine details. But generally, when you're talking about people who are going to write you a sizable check and and have the means to do it, and if they have a history of supporting people who are doing the kinds of things you want to do, they're going to just read the executive summary and make their decision from that. So you have to have enough information in that executive summary that they can make a sound decision. A typical executive summary, 3 to 5 pages. Your executive summary might be 2 or 3 pages long. In that summary, you need to define the problem or the need or the goal of what you're trying to accomplish, um, the decisions that need to be made, the expected outcomes, and provide the reasons why you think those outcomes will happen. Um, you need a call to action. This is what I want to do. This is how you can help me. You need, in the brokerage industry, we would say you need to ask for the order. You need to actually say, would you consider investing $10,000 into um, my next recording or whatever it is that you're asking for. Um, so it it's a way to say, this is what I'm trying to do. The business plan has all the supporting documents. The executive summary says, this is who I am. This is what I plan to do. This is how I plan to do it. This is how you can be involved in that. Here's what I expect to happen money wise and success wise. And that's all contained in that executive plan or executive summary. The executive summary, again, is going to be 2 or 3 pages long, um, and will be uh, will have all of the points necessary for somebody with a checkbook to make a decision on whether or not to fund you. Okay? That's what you're writing for this week, executive summary. Okay. Let's see, a few things. Oh, I do have a few things not to do. You don't want to get too wordy on this. You don't want to use technical jargon. Um, don't use passive voice. Use active voice. I'm sure you understand that at this point because you're writing a research paper and you're going to write that in active voice. If you don't understand active versus passive voice, just Google active voice versus passive voice. Don't cut and paste information. Write this as a fresh summary. Okay, so it's not just taking what you've already done and just cutting and pasting. Actually, write a summary that somebody can then use to make a decision. All right, we are continuing. We're going to cover chapters 18, 19, and 20 today, and this is about. There's a lot of information here. Some of it gets a little tedious. I'm trying to avoid the stuff that gets um, uh, too esoteric. I figure that at some point you can pick up the book and read it if you're really interested in it. So, but there are some things that we do need to look at, and since some of you are writing songs and you're writing songs with other people in the class or potentially doing that, this is worthwhile. Chapter 18 is about songwriting, co-publishing, and administration deals. Songwriters agreements. Okay, typically, um, now this isn't record deals. If you record a record, you enter into a deal with a record company. That is different than songwriting. Songwriters and music performers are two different categories, or two different sets of people. They may be the same individual. The person, the artist producing the record may be, or singing on the record or playing on the record, may be the same person who wrote the songs, like Taylor Swift. More often than not, they're two different people. There's the artist that performs, and then there's the songwriter that writes the songs. The artist performing, that performance and recording, you do deals with record companies for that. On the other hand, the person writing the songs is dealing with a publisher, a music publisher. Typically, in songwriting agreements, if you wrote the song and you're in an agreement with the publisher, you get 75% and the publisher gets the rest, 25%. With some heavy hitters in the industry, songwriters can get up to 90%, especially if you take smaller advances. Big publishers will try to take 10% off the top of that for administration fees. And what you want to state in your contract, if you can, if they'll allow you, 75%, 25% split with no admin fee. So it would work this way. If you received, if we were talking $10,000, 75% of $10,000 is $7,500. So you get 75, they get 2,500. But if they take administrative fees off the top, 10%, then you get 75% of $9,000, which would be like 6,700 or 6,750. So you want to make sure, if you can, and you may not have this clout, but you want to try to get a contract that has no admin fee on top of that, so that the splits are actually the 75-25 is actually 75-25. If you work with an independent publisher, you will get the additional fee because the independent publisher is having to pay a bigger publisher to have access to the markets that you're trying to publish in. So they have that fee, um, and so you can expect that. Of course, the more clout you have, the better the deal you can arrange. But typically, it's 75-25. What gets split? Um, you want your deal to be at source. That is, in the different areas that the agreement covers, and different locales too. You want each of those areas to be your percentage at that point, instead of uh, having publishers take a portion of it again before it passes to you. Um, you can't get you can get those deals with sub publishers and big publishers. You're not going to get it with independent publishers because the independent publishers are having to go independent. You would be, if you wanted to open your, we talked about in last class, opening your own publishing company. If you develop your own publishing company, you still have to have access to the markets. So having your own publishing company simply means that you function as your publisher, but that publisher still has to access the markets that the big guys have developed. So if you're an independent, or if you work with an independent publisher, they're going to have to pay to access for these areas. So you're not going to get at source deals. You're going to get a deal that includes fees on top, and that's the way it works. That's the only way you can do it. Performance monies. Remember that the performing rights organizations pay songwriters directly, instead of paying the publisher. Um, that happens with all other income from your publishing deals. Um, so you might get 50% of the performance money directly from your PRO. Your PRO is going to be CSAC, BMI, or ASCAP. It's going to be one of the performing rights organizations. So that performance money, the money you get for performing, is going to come from them, or not for you getting. It's the money that you get when somebody performs your work. So if you write the song and somebody performs your song in a concert or in another church, if you're a Christian musician, when somebody performs your music, you get money from that, and 50% of that generally is the cut that you get as a songwriter. It's not a good writing songs is not a bad gig. If you if you are if you love music, you express yourself well in music. The whole touring thing and performing thing gets you nervous. You can make a living as a songwriter. Um, so, and that's what Chapter 18 is about: writing songs and getting paid to do it. Direct licensing. Remember that your deal with the publisher gives them the right to license your songs. The right is not exclusive, usually. So if you get if you're working with a publisher, the publisher can license the rights to your song for somebody else to perform, but that doesn't mean that you can't. So it's not an exclusive thing that they have. It's something that they can do, but that doesn't limit you from you doing it too. So you can directly issue, like if I wrote a song and CSAC, and I had registered the song with CSAC. CSAC could issue licenses to people to perform my song, and whenever somebody performed that song, they would pay me for that performance. In addition, if I wanted to take an individual song and license it specifically to somebody to perform, I could do that. So if Martin decided that he wanted to take one of my songs and put it on his CD, and I said, "Oh, I know Martin. Martin, I'll only charge you $100,000 to put it on your next album," then we could do that separate deal. So it's not an exclusive contract. Um, let's see here. Uh, um, use the term catch-all. Okay, the publisher when the publisher writes your contract, this is a contract issue, and again, a good attorney should catch this. If you're writing up, if you're offered a contract by a publisher for a song or set of songs, you want to make sure that the publisher will say this covers these events, so that the publisher says they'll pay you your fee for if the song is printed here, or if it's uh, used here, and they'll list those things. You want to make sure that there's a catch-all phrase in there, a phrase that says and any other sources of revenue. Otherwise, by listing how they're going to um, market your song, if the list that they have you sign um, is uh, does not have a catch-all attachment to it, they can find if they find another way to earn revenue off the song, and it's not listed in your contract, they can keep all that income. So you want to make sure that it's these things and anything else that generates income. That's called a catch-all phrase. Um, Most contracts do not give you a cut of any advances that the publisher gets. Remember that. No one knows which songs will be a hit, so there's no good way to do that. So if the publisher if you're doing a 6-song um, advance with if you're doing a 6-song contract with the publisher, and they don't know which songs are going to be hits, it's real hard to get an advance on a particular song. Sweetheart deals. If your publishing company is affiliated with your record company, which is not unusual, be sure that, for instance, if Warner Brothers is your record company, and Warner and Alfred Music is your publishing company, and Alfred Music is a subsidiary of Warner Brothers, make sure that your contract says that your music publisher can't give a sweetheart deal to your record company, because they could negotiate between the two of them so that they inflate their um, actual costs against your revenue, the revenue that your song's generating. So make sure that you have a clause in your contract that says this is done on an arm's length customary basis. It means whatever deal your record, your publisher and your record company cut together, whatever deal they cut together, any other person should be able to cut the same deal. It should be customary for the industry. Charges against royalties. That's the amount the publisher takes out of your share before they pay you. Okay, so you've entered. Again, we're not talking about being an artist on a recording. We're talking about you writing the song. So you've written a song, and there's the traditional splits that happen before that money is split. The costs involved um, that the publisher is going to take a percentage of the costs involved on that total income that comes in. So that's going to be stuff like sub-publishing fees, collection fees, like if Harry Fox is out coming to Calvary and saying, okay, you have to pay 11.5 cents per recording per CD for this performance. There's 11 CDs, you got or 11 pieces on the CD. So you owe us $900. Okay, well that's a Harry Fox fee, and Harry Fox is going to take that and that comes off of the top before your actual revenues are distributed to you. Sample clearances. Okay, I don't think any of you are using samples in your music, but you might. If you do rap, rap uses a lot of samples where they'll take a sample of another existing work and pull that into their rap piece. Those samples have a cost associated. That would come off the royalties before the royalties are split, and you get your before you get your income. These are all charges that come off the top. Charges that come off the top are shared. So if you get, again, we go back to the $10,000. You're getting 75% and your publisher's getting 25%. The stuff that comes off the top, like the fee to Harry Fox or the cost of the samples, or those things, that comes off the top before the fee is split. Then there are things that come out of your fee. After the fee is split, you handle 100% of those things. Those things are those costs that come right out of your share of what comes out after the split, after the actual revenue split, are going to be things like advances that you've received. If you've received an advance, you have to pay it back, and so that comes out of your royalties. If somebody sues you for infringement of copyright, those fees come out of your side of the royalties. So court costs would come out of your side of the royalties. So just remember that you're responsible for if you anything that you actually cause in terms of a cost, that's your responsibility to pay that back. That shouldn't surprise you. So, but that's the way it works. So advances are simply loans on future work that you're going to do. So if you get a $10,000 advance on a set of songs, what they're saying is we're going to prepay you your first $10,000 worth of royalties. That's all an advance is. So they expect to have it paid back, and they expect to get it back from the royalties. Copyright ownership. That's a lot of information we're covering here. I hope you're still focused on this. Be sure you're reading through. I'm going through the book. I don't hit everything in the book, but that's if you're following along in the book, that's where we are. Copyright ownership. Under these deals, who owns the copyrights of your song? Historically, the publisher owned 100% of the copyright. We'll talk a lot about copyright today. Normally, once your deal is over with the publisher, you get the copyright back. And so a deal might last 10 years. So when you enter into a deal with a publisher, you actually sign over the rights to your copyright on your song or your songs. The reason that is that the publisher is the one that's out hawking your music and selling it. And they want, it costs them money to do that. They've advanced you money, probably. And it's important that they have something that will protect their investment in you and your song. So they have the rights to your copyright for a period of time. Let's say 7 to 12 years, but typically it's 10 years. And they normally they give you the rights for that song back to you after the deal is over. If you it says my notes say if you have clout, you can shoot for shared ownership with the rights reverting back to you at the end of the deal. That means that simply that during the term of the deal, instead of them having 100% of the copyright, you can negotiate a partial ownership of those copyright um, benefits. So you can own part of the copyright, they can own the other part of the copyright. But normally you're signing over your rights to the song during that time. That's how you can have a situation where uh, somebody who's very famous no longer owns their songs, no longer owns copyright on their songs. Um, there is there is another version of this, an administration agreement is when the publisher doesn't own any of the copyright, um, and another entity does. We can talk about that in a little bit here. I think we get to it if we have time. Single song contracts. Major uh, songwriters. Major songwriters rarely do a single song contract. They're normally going to do a contract with a publisher for 3 or 6 songs. Generally, that's kind of the 3 songs for 3 to 6 songs, let's say. But sometimes, every once in a while, they'll do a single song contract. The when songwriters do single song contracts, it's usually for a movie. So there's a movie soundtrack, and they need a song in that movie, or maybe in credits, they need a song, and so they'll do a single song for that single song contract. The advances are minimal. You might get $250 to $500 to do that kind of contract. Um, so as an advance. So so those things are out there. Uh, Terms songwriter agreements. Okay, a term songwriter agreement is like a record deal, except that instead of making a certain number of records in a certain period of time, you agree to give the publisher all of the songs you write during a specified time. The term is usually 1 to 3 years, and there are normally options to extend. Some publishers require a minimum number of songs, usually 3 songs per year, and this is called the minimum delivery requirement. If you are one of the several writers of a song, they'll count. So if you have a partner, there's 2 of you, and you sign a contract for 3 songs, your song count is half of the. If you're a 50-50 partner with your songwriter, you're counting half your song as a song. So you would have to co-write 6 songs to equal 3 songs that you wrote yourself. That's the way the deals are set up. So you get fractional song credit towards meeting your song delivery requirement. Um, on these kinds of deals, you're going to get an advance. Usually in the contract, if you say, okay, I'm going to have a 2-year contract with the publisher, and I'm going to write 3 songs per year over the course of 2 years. So I'm going to deliver 6 songs. At the end of 2 years, if you haven't delivered 6 songs, normally there is an extension in the contract until either they get their number of songs or your original advance has been recouped. Um, you can add some wiggle room to your contract if you are unrecouped at the end of the term. You can buy your contract out. So if I was supposed to write 6 songs and I have a 2-year term with the publisher, and uh, I only wrote 4 songs, and I have 2 that I've written that I don't want to give the publisher, and my term of agreement is up. I can buy normally in a contract. They'll allow you to buy out the rest of your contract. Generally, you have to pay 25% over what's left, and it's based on your advance. So if you got $100,000 advance, and 70,000 of that advance has been um, recouped, then you need to you would owe the publisher 30,000 plus maybe 25% of that 30,000 to buy your contract out if that's allowed in your actual contract. So that's you can ask for the publisher's not going to offer that, obviously. You can ask for that, and it gives you some wiggle room. The other thing is if you don't deliver all your songs, but the ones you did deliver were smash hits. So you're supposed to deliver 6 songs, and you only delivered 4, but they all went on platinum and made huge money for both you and the publisher. Then you you can include in your contract that if you recoup your advance, even though you haven't delivered all your songs, that you have the right to end the contract at that point. So that's difficult. Actually, if you're really a successful songwriter, the publisher doesn't want to do that. But if you're a really successful songwriter, you may be able to demand it and get it in your contract. And so, and basically, it's if I make you, you're saying to the publisher, if I make you a lot of money, I get out of my contract without having to deliver all my songs. So, um, uh, some folks can get those things in there. I'm just telling you it's a possibility. Advances. New songwriters picked up by major publishers will get somewhere between $18,000 and $100,000 advance. That's the going rate. If you're a major songwriter, you can get anywhere from a few $100,000 up to 7 figures. But by the time you get to that point, you know the game, you know the business, and that's a whole nother conversation. But if you're just starting out and you've had some success with your songwriting, and a major publisher wants to have a deal with you at the beginning, they're going to give you somewhere between 18,000 and 100,000. They're always looking. Publishers are always looking for new talent. They're always looking for good talent, and so they have a vested interest in investing in you. They want to find the next, Beatles or Coldplay or ABBA or whoever can write songs and sell records. So so just be aware of that. So you might get in terms of the advance, the way they pay out the advances. Here would be a typical contract. You get a 2-year term with 6 songs. So they're expecting 6 songs from you, 3 songs a year over the next 2 years. You get 50% at signing. So if they signed you for 100,000, if they really thought you had a lot of potential, they'd give you 50,000 up front. They'd give you 20,000 a year later, 20%, and then 5,000 every time you delivered a song, which is 5%. So it's 50% up front, 20% the second year, then 5% on each song. And I've got in my notes, you can make a great deal of money writing songs for other people. Record deal tie-ins. Some companies will try to grab your publishing when they sign you to a record deal. Don't do it, especially if it's an independent record company. If you're working with an independent record company and they want your publishing rights, they're just looking for more money. They're not going to be able to do anything with it. They're not the people you want as your publisher. When you do, if you are a writer artist, you want to get the best record deal you can with the best record company, and you want to get the best publishing deal you can with the best publisher. Generally, those are two different people. Okay? Co-writes. Songs written with other people. Okay. When you write a song with another person, and I'd say 95% of all songs are now being written by 2 or more people. Lots of collaboration in songwriting, and it's because certain people have certain gifts in certain aspects of writing songs. So if you are co-writing songs, if you become a songwriter, that's the path you want to take. This applies to you. Songs written by 2 or more people. Normally, songs are split 50-50. The person who writes the lyrics gets 50%. The person who writes the music gets 50%. That'd be a basic vanilla songwriting relationship. Um, the that there are, if you think about it, there are certain things that will change that. Let's say that one of you writes the music and then both of you write the lyrics. One of you writes the tunes and the harmonies and everything. One of you does that, and then the two of you together write the lyrics. Then that might be a 75-25% split, or a 2/3, 1/3 split. That's something you can cover. It's a negotiable. There's nothing. The law doesn't say you have to do it a certain way. But typically, for co-written songs, you split it evenly with everybody who participated. You'll see in worship songs this whole stream sometimes of people who've written songs. 5 or 6 people will be involved. If you go to CCLI and you look at the writers on a Christian worship song, staggering number of people, sometimes 6 people involved in writing a particular worship song, and they all have a claim to the song as songwriters. Creative control. Creative control gives you the right to approve changes. Once you've written a song and you've signed over the copyright to the publisher, you no longer, basically, you no longer own that song. The copyright is owned by the publisher. But usually in a contract, you can keep creative control over certain aspects of the song. So that would be like if a change in the lyrics, a change in the music, maybe a change in the chords, chordal structure, whether or not you can use the music in commercials or ads, brand rights, which are, that's another discussion, but I mean, just rights in general, how the song is used. Even though you no longer own the copyright and it's been assigned to somebody else, you can maintain creative control and say, okay, this is my work, but you can't do certain things to it. And matter of fact, at the end of chapter 20, it talks about moral rights. I was going to talk about that because it doesn't really apply to music, but it does apply to artwork. Moral rights are similar to creative control. They're cousins. If I'm a painter and I paint a painting and I sell that painting to you and I become famous, whether I become famous or not, but let's just say I become famous and the painting is in demand, and you sell it to someone else, and they sell it to someone else, and all of a sudden there's like 4 or 5 people who've owned the painting, so it's gone through the marketplace. Number of people have owned it, and the final guy owns it, and all of a sudden he decides that he wants to draw a mustache on it, or he wants to cut it up and to turn it into confetti, or he gave it to his wife and now it's his ex-wife and he got it back in the divorce settlement. She loved the painting and he can't stand her, so now he's going to destroy the painting. Okay. Moral rights say that even though I did the painting and I sold that painting to someone else, I can still control whether or not somebody can mar, change, or destroy the painting. So even though I no longer own the painting, I still control negative aspects of what can happen to it. It's called moral rights. That applies to music, but I don't know that it's ever been used because it's really hard to determine something like that with music. You can't really destroy music. You can re-record it, but that would come under creative control. So creative control is even though you no longer own the copyright, you can still exert control over how the song is used. A reversion of copyright. This means that the publisher must give you back the copyright sometime in the future. This is easiest for songs that haven't been exploited. A song is exploited once it's published. Um, so if you do a recording and that that recording is never released, it's easy. It's easy enough to get the rights for that recording back, the copyright. Once a song's been exploited, that is, once it's been released to the public, then it's a lot harder to get copyright back from the publisher. Um, Again, normally there's an automatic reversion, usually 7 to 12 years out, um, and if you've and it's dependent on whether or not they've recouped the advance. So they gave you an advance, you wrote them the song, they had somebody record the song, and they've gotten all their money back and made a bunch of money. Somewhere 7 to 12 years out, once all that's happened and they've gotten their advance, the money they paid to you for an advancement, they've gotten that back, then at some point in the contract, and it has to be in your contract, make sure you do that, you're going to get the copyright back for your music, for your song. And the, um, the thing to remember there is the payout period for a piece of music takes a while. So somebody may use, during the period the publisher has the copyright, and somebody licenses it in a correct way to use it. It may take them a year to get that money from the person that they licensed it to, because it gets complicated, but it's a long process to get paid. Even though the copyright reverts back to you, if the licensing revenue was generated but not paid while they held the copyright, they're still um, uh, able to claim that income, even though it might pay out a year later. And it'll say in your contract that you want to specify period will be 1 or 2 years out, so that they can still get their money. You can do partial reversion. That's where you get partial rights, maybe 75%, and the publisher keeps the rest. So you can get partial reversion of copyright. So it is possible to co-own copyright. We've already talked about that. Administration agreements. Publisher does not get copyright ownership. Instead, they get administrative rights for a period of time. And it's usually between a big publisher and a smaller publisher. It's not going to be between you and a publisher. It'll be between maybe you're a publisher, you've decided to open a publishing company for your songs, and you then work with a large publisher to get your music distributed. Okay, so in that case, as the smaller publisher, you maintain the rights to the song, and you hire the big publisher to do the administration. Normally, they're not going to bother if you're a new songwriter. You're not going to be able to do this. But if you're an established songwriter, you're going to start your own publishing company. You're going to want to do that so that you don't have to sign over your copyright to a big publisher. You sign it over to your own publishing company, which you own, and then you do an administrative deal with a big publisher so that they can market your music. Usually these contracts are shorter term, 3 to 5 years. The advances, of course, are going to be much smaller because they're it limits the amount of money that the big publisher is going to make. So there's no reason for them to pay. If you're retaining the rights, it prevents them from earning certain monies, and so they're going to pay you less up front. The administrative share, the way administrative rights work is the administrator gets a fee, reimburses itself for any direct expenses, and then pays the balance to you. Typically, administration rights, remember, you're going to be the publisher. You're now pretty well known. You open your own publishing company. You're working with a big publisher to get your music out. They're usually going to take 10 somewhere between 10 and 25% of gross to do that. Covers and co-writes. If the publisher brings in a big artist to record your song, so you write the song and um, they sign Chris Tomlin to record your song on his next album, they're going to get a bigger cut of administration fees. So, or if they bring in at some point, which happens often actually, Chris Tomlin to help you finish your song. So, not so in this case, Chris Tomlin could be the guy who's performing your song on his next album, or the publisher brings in Chris Tomlin to help you finish your song and get it ready for release. In both of those cases, they're going to add usually 10% or so that if they were charging 25% of gross, they might charge 35% of gross. Again, this happens much more often than you realize. They're indescribable. Um, uh, the original had who wrote that? Laura Story. Laura Story wrote um, "You Indescribable," and the refrain is "You are amazing, God, all powerful." Da 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 da. Awestruck, we fall to our knees and we humbly proclaim, "You are amazing, God." She met with Chris Tomlin before they released that song, and her original words were, "You are an amazing God. You are an amazing God." And he said, "It'll sing a lot better if you just say, you're amazing God. You are amazing God," instead of "you are an amazing God." The takeout of that and then, yeah, if you know the song, you go, well, how would it even have worked with the word "and" in it? But Laura Story was still in college when she wrote that. And by taking that word out, Chris Tomlin has writing credits. I don't know what else. I'm sure he helped with other parts of it. But Chris Tomlin has writing credits for that song because he was involved before that song was published. So, but if you have a chance to have Chris Tomlin help you with your song, go ahead and have him help you because he's really good at what he does. So that's how it works. Co-administration agreements. If you have many co-writers with different publishers, everyone takes their own share. That's the way it works. So you just keep chopping up the pie. The way accounting is done in the business, monies are usually paid every 6 months, sometimes quarterly, but usually every 6 months, and it's done after accounting periods close. So it's going to take, if you had a song out there in 2019, the money that you earned from July 1st to December 30 would have been paid out to you sometime um, around April 1st, maybe mid-March, April. So it takes a while to get paid in the industry, and that's just because they have to do all the accounting, um, and just be aware of that. Writing teams, and this applies to situations where let's say you have a band, and the band, Coldplay works this way. Coldplay is the band is a writing team. So my understanding is their record deals and their publishing deals are all split. Everybody gets 25%. Advances stay the same whether you're one person or 100. So if the record company were going to advance you, um, or not the record company, the publisher, because this is songwriting. If the publisher were going to advance your team, say 4 band members, in advance, and they were going to give you 50 grand, they're going to give you 50 grand if just one of you is the songwriter, they're going to give you 50 grand. If all four of you are the songwriter, you have to split it. The more people involved, the more you have, the less everybody gets, because the amount that they're paying for the songs isn't going to change depending on how many people are writing it. If you cross collateralization, okay, this is real important. If you're asleep now, we're an hour into this, and if you're asleep at this point, I don't blame you. Listen to this, so this is important. If you have a songwriting team that's 2 or more people, so let's say that everybody in the class gets together and decides to write a song, and the song's a big hit. And you find out that, and then the publisher comes to you and says, I'm going to give you a $100,000 advance to write 6 more songs over the next 2 years. That means each of you are going to get $25,000. They will want a cross-collateralization agreement in the contract. A cross-collateralization agreement says that if somebody doesn't uphold their part of the contract, that everyone else left in the contract gets to cover for them. It's like co-signing on a loan. You want to make sure that's not in the contract. It'll be in there unless you specify that they take it out. So, the way that would work is, let's say that there were 4 of you. You got the advance, each person got 25,000. And then 6 months into the 2-year contract, 2 of you decide to go off and start your own band, and or 2 of you go off and decide that you're not going to write with the other two guys and gals. That advancement, that half of the advancement would have to be recouped, and the way it would be recouped is by the remaining people who are songwriting. So that would be everybody got 25,000, but the 2 of the people left, and so that their 50,000 has to be covered by the 2 people that are remaining. So even though you only got 25,000, you're responsible for another 25,000, or there were 2 there. You're responsible for both of them. So you don't want to be part of a cross collateralization agreement. And just like that, you don't want to be part of separate obligations. Or you want to keep separate obligations. And the way that works is that you don't want to be, a separate obligation would be this. If I decide to write a song with let's say Jeremy Shell. Jeremy and I decide to write a song together. And Jeremy, and we get a $100,000 advance. He takes 50,000. I take 50,000. And and we don't have a cross collateralization agreement. There's still a breach of contract. And so my job is our job together is to deliver, let's say, 6 songs. We've only delivered 2 songs. There's a breach of contract in that we have, as a team, have not delivered the other 4 songs. A separate obligations agreement says that I can't be sued for the fact that he's not maintaining his part of the bargain. Okay, so make sure that you keep separate contractual obligations. All right, that's chapter 18. Chapter 19 and 20 are going to go more quickly here. This is just copyright, and we want to continue to talk about copyright. Chapter 19 of the 3 chapters for today, probably the one on copyright is the one that's going to most affect you, and something that you really need to be on top of. Who owns copyright? If you wrote it and you didn't assign it to anybody, you own the copyright. That's the way it works. If it's co-written, you both own it. Okay, so if I write a song with somebody else, we both own the copyright, but each of us can deal non-exclusively with the entire composition. And what that means is that if I write a song, let's say Jeremy Shell and I write a song, and I can license that song to anybody else without Jeremy's permission, but I still need to pay Jeremy his 50% of the rights of the revenue. So I can't give exclusive rights. I can't take the song and give exclusive rights to somebody as an individual, but I can give non-exclusive rights to somebody to use the song, and Jeremy can't say no, but he still gets his royalties. Okay, so there is also something called works for hire. Let's say that you work for Disney, and Disney says we need a new theme song for a new ride. We're putting a ride up in the park, and we need a song. So you're a staff writer for Disney, a staff musician, staff music composer and arranger for Disney. When you write that music, if you're writing it for hire, Disney is the owner. Disney's the copyright owner. You're going to get paid as the songwriter. And you're going to get paid pretty much what you get paid regardless, whether you're the songwriter copyright holder or the songwriter work for hire. You just aren't going to own the copyright. So Disney can do whatever they want to with the song, but any royalties, you're probably going to get those royalties paid. But remember that when you do something and work for hire, somebody else owns the song. A few years ago, I was asked to write a song for a new school song for Calvary. I wrote that song on my own time, which means I own the copyright on the song. If I had written the song on Calvary's time, they could claim that it was a song for hire, and they would have the rights to the song. So that's the way it works. And if they had the rights to the song, they could do whatever they want to with it. But in this case, I wrote it on my own, so that song belongs to me. So, and I can do whatever I want to with it. So that's just an example of how it works. There are some strange little idiosyncrasies that go along with this, and you can read about that if you want to. It's in again, it's chapter 19. Duration of copyright. Copyright lasts, and I think we talked about this maybe we didn't talk about it the last cycle. Copyright typically lasts for the life of the author plus 70 years. Copyright law has changed. The book goes through all of these history of changes that have happened with copyright. Don't let that get you confused. It simply works this way. If I write something, I own the copyright. If I don't assign it to someone else, I own the copyright. If I die, I own the copyright, but now that goes to my estate. So whoever gets my car and my bank account and my house also gets the copyright on the song I wrote. That copyright lasts for 70 years after my death. That works. It's a book, it's a song, it's an opera. If it's some hymn that somebody wrote, all of that is copyrighted for life plus 70 years. After that, it becomes public domain. Public domain means that anyone can use it any way they want to, basically. So if somebody wrote a hymn in 1920 and they died in 1935, their copyright would have ended in 2010, and now that hymn is public domain. If somebody were alive in 1940 and they wrote a song in 1940 and they died in 1950, the hymn is still under copyright. So that's what you need to know about that. If it's a joint work, if you and your writer friend write a song, the copyright lasts until the death of the second person. If the song is anonymous, it lasts 95 years from publication or 120 years from creation. If it's a work for hire, it's the same as anonymous. So if Disney Disney has stuff that they wrote. I think everything at Disney is still under copyright. But in the next 40 or 50 years, there are Disney songs that will no longer be copyrighted. So once and those aren't anonymous, they're works for hire. But works for hire and anonymous songs after 95 years of release or 120 years after creation, those are no longer copyrighted. That means that one day Frozen, the score to Frozen, will no longer be copyrighted. One day, all the Beatles songs will no longer be under copyright. They'll all be public domain. So everything, copyright ends for everything eventually. The right of termination. Right of termination is if you make a dumb deal with your copyright stuff. You sell your copyright to somebody. Now that's not what Taylor Swift did. We keep bringing her up. She sold the masters. She sold her master recording. But for copyright, there is a right of termination. You can get your rights back after 35 years. It's only in the United States because it's every country is different. But in the U.S., if you're 17 years old and you write some songs, and Warner Music gets the publisher, and they have full rights to your songs for 5 years, and that's when you do your best stuff. And so now you're 25 years old, and all of your best songs, the copyrights for all your best songs are owned by Warner, and you want to get them back. Okay, 35 years after you signed them over, you have a right to reclaim them. The copyright doesn't end at that point, but you can get them back. It doesn't end, the copyright doesn't end, but who owns the copyright can change. So you go to Warner, you give them notice, you got to do it. There's a certain time period you have to do it within, and then after 35 years, they can be forced to give you your copyright back. That's something I don't know that a whole lot of folks know that, but something to file away. All right, what happens when somebody rips off your copyright? So let's say you write a song, and somebody steals your copyright. Or steals your copyrighted music. So years and years and years ago, George Harrison wrote, my sweet Lord, my sweet Lord, my sweet Lord, okay, so that, and before that, there was a group that wrote a song called She's So Fine, and it goes, she's so fine, da-da-dun, da-da-dun, she's so fine, da-da-dun, da-da-dun. Well, they sound a lot alike, at least certain parts of it, not the whole recording. But that went to copyright infringement. That's an old one. The latest ones, Infringement of copyright is when somebody uses part of your composition without your permission. Marvin Gaye won a $5 million. Marvin Gaye's estate. Marvin Gaye's dead. Marvin Gaye's estate won $5 million from Thicke and Williams for Blurred Lines. So I'm not. I'm not a. I. You may not want to go back and watch any of this, but Blurred Lines is a recent, somewhat recent song. Marvin Gaye, if you just go YouTube it, you'll see, you'll hear the two songs, and sure enough, there is the underlying beat. It sounds very similar on the Thicke and Williams song when compared with the Marvin Gaye song. Okay, so Marvin Gaye's estate won that $5 million settlement. Led Zeppelin, just in the last month or two, finally settled something that's been going on since I think 2014. A band called Spirit had written the riff that goes the opening to Stairway to Heaven, Led Zeppelin Stairway to Heaven. Ba da dee da ba da dee da 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 dee da 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 dee da dum da da dun da dun da bum bum. Okay, so opening Stairway to Heaven. There's the same chord progression that Spirit uses in a song that happened. It was nobody knew the song, nobody knew the group, but they did it years earlier before Led Zeppelin did it. That went to court, and that was actually resolved in Led Zeppelin's favor. Again, you can go to YouTube and put in Led Zeppelin lawsuit or Stairway to Heaven lawsuit and hear the two songs, and then hear people explaining why that lawsuit didn't come to fruition. So Led Zeppelin successfully defended Stairway to Heaven against infringement lawsuit. So you write a song and somebody steals a part of it. It could be a particular chord progression. It could be a certain beat that's been set up, a rhythm. It could be lyrics, some aspect of the song that clearly, or maybe not clearly, has been lifted off of something you've written. This is what you do. The first thing you do is you file a lawsuit if you're the copyright. If you're not the copyright holder, you can't do anything. But if you're the copyright holder or the beneficial owner, you file a lawsuit. You have to make sure that you're registered with the Copyright Office. If you're not registered with the Copyright Office, you can't. There's certain things that you can't do. So you make sure you're registered with the Copyright Office. You have to file within 3 years of the infringement. There is a wrinkle in there where you can. It's 3 years of when you actually are aware of it, but normally that's when the infringement happens. You have to prove that you got ripped off. There are two standards that the courts use in their legal terms. One's called striking similarity. So there are times when, like for instance, with the George Harrison song, "She's So Fine with My Sweet Lord," there is a striking similarity between the two pieces, and striking similarity is all you have to show. If it's that clear, if there's a clear, if infringement has actually happened and it's clear, that would come under striking clarity, similarity. There's also something called substantial similarity. Substantial similarity is that they're pretty close, but there's questionable whether or not it actually is. It's not as strong as striking. Striking similarity is pretty clear. It's a done deal. Substantial similarity, you have to show that that the person who's infringing, the person who stole your work, actually had access to your work. Okay. Now, in this case, we talk about George Harrison. George Harrison probably heard "She's So Fine" because it was a well-known song, early '60s, late 50s, early 60s. Was it Shirelles or can't remember who recorded that, but it was, you probably heard it. And so George Harrison probably heard it. George Harrison's defense was because it was substantially similar, and George Harrison would have, in the normal course of things, probably have heard the song. George Harrison's defense was, okay, that may be true. I may have heard the song, but I was not consciously aware of the song when I wrote my song. So there's a whole bunch of stuff that came out of that. George Harrison still lost, but the uh, if you can prove one of those two things, then um, then the sued person, the person being sued, would have to prove that they didn't copy the work, which is a lot harder. So you must prove that you created the material yourself. If you're trying to defend yourself against copyright infringement, you'd have to prove, if you're the infringer or um, the accused offender, you'd have to prove that you created the material yourself, and that and then you can refute that um, lawsuit. Though, if you you still have to, if you're the copyright holder and you're crying infringement, you still have to prove that what you wrote is original and not copied from someone else. So, in the case of Stairway to Heaven, they not only had to prove that they, no, that's probably not the best. Yeah, we can use Stairway to Heaven. That you have to prove, if you're saying somebody has infringed on your piece and they've stolen something from your piece, you have to prove that what it is that they stole is actually unique enough that it was stealable. In the case of Stairway to Heaven, the opening uh, uh, guitar uh, solo has been used over and over and over. The progression has been used over and over in songs. And so part of the problem with that is Spirit didn't have a leg to stand on, because there was there wasn't clear um, the the information that was claimed that was stolen from their song. They had indeed reflected them, not that they had stolen it from other people, but it was already in existence before they wrote their version of the song. So so they couldn't prove that they were original in their that there was any original creativity involved in the original work that was supposed to be infringed upon. So when you go through all of that, the courts then decide how much you've been damaged, what was the fair market value of the use. So if you show that somebody, you write a song and you're a struggling artist in Kansas City, and you're barely making enough money to pay for your food ticket over in the Student Life Center, and you write a song and somebody steals a verse from it, makes $1 bazillion selling that song. What you'll get is fair market value for whatever they sold that song for, that portion of the song. So if it was $25,000, you get $25,000 from the people that you're suing. In addition to that, you can sue for any profits that the uh, infringer has made. You can get an injunction against the song that has the copyrighted material in it, that it can't be played. You can get statutory damages. Statutory damages would be damages where there isn't a clear idea of what it actually, what that song would have actually made. So it's just set by law. It's going to be somewhere. The awards are going to be somewhere between $750 and $30,000 per incident. So every incident of that song being used, um, that song that infringed on copyright, every instance where that song is used can be fined anywhere from $750 to $30,000. But you have to have the song registered with the Copyright Office for that to work. So that's why you have to copyright. That's why you have to register your songs, is because when you register your songs, it allows you to sue for statutory damages. And then the court can order destruction or seizure. So if the guy who copied your song, he's got his CD, he's got 10,000 CDs with that song on it. The courts can destroy all those CDs or seize the CDs, and uh, and then if it can be shown that the copyright infringement is intentional, then you can have criminal penalties also. And you can sue for court costs, attorney fees, and stuff like that. All right, that's chapter 19. Chapter 20, even more advanced copyright concepts. Okay, this chapter has lots of great information. If you're still watching at this point, I'm going to let you off easy here. We're almost done. It has lots of information that you should read, but I'm not going to cover it. It pertains to copyright of older songs, golden oldies, recordings from the past, details on how you get your copyright back after 35 years. Um, it's stuff that we don't need to cover for this class, but that's there. You can go back and read it. That's pages 329 to 339. So, okay, finally, registration and deposit. We've already talked about this. You don't get copyright by registering your work with the Copyright Office. There's copyright and there's registered copyright. Copyright happens as soon as you have your piece, whatever it is that you have, in a fixed, tangible form. Once you fixed it, once it's tangible, it's copyrighted. It's not registered copyrighted, but it's copyrighted. What you receive from registering, there's certain legal protections you get, and this is why you want to register. Um, we've already talked about um, uh, statutory damages. You can sue for statutory damages. You can't get a compulsory license. You can't collect compulsory license royalties without it. So compulsory license, we talked about compulsory license last week. And those royalties, you can't collect those royalties unless the work is registered. You can't, we've talked about this, you can't file an infringement action. You can't file a lawsuit against somebody for copying your work unless the work is registered. It must be registered in the Copyright Office. If you don't register your work within 5 years of publication, and you would, I can't imagine you'd publish a work and not register it with the Copyright Office. But if you do that, after 5 years of publication, if somebody accuses you of infringement, the fact that you registered your song earlier and you registered it before a certain date, and you can show that, it's assumed that whatever information you put in that registration, that the information is true and correct. If, on the other hand, somebody steals your song and you wrote the song 10 years ago and you never registered it, and you register after the fact, somebody sues you and then you register the copyright, it will be assumed, it's no longer assumed, it's no longer presumed that the information is true. So you can't use that information if you wait 5 years after you've released a piece, you published a piece. If you wait over 5 years to register it, you can't use the registration information as proof that it was registered at a certain time. Okay? Or certain aspects of the registration that are, you can, you lose that as a form of proof. Um, there's that's registration. There's something called deposit, um, obligation to deposit. When you do register, you have an obligation to deposit within 3 months of publication, the best edition of your work. So that's just something you need to do. So that's all. So what I'm trying to do here is, though you do not have to register your music. If I wrote a song and I wasn't going to do anything with it, so if I wrote a song, didn't do anything with it, I would not register it with the Copyright Office. If I didn't publish it, if I didn't record it, I won't worry about it. If I wrote a song and I performed it at churches, I would definitely register it with the Copyright Office, because now basically it's now public. It's now in the public sphere, and now there's a possibility that somebody might lift information off of it. Maybe they take a verse, maybe they take a chord progression out. So I want to make sure that I've registered the song if it's going to see the light of day in the public. That helps protect my rights and my copyright. I still have the copyright, but by registering it, I protect those rights. Now there is something called, we've talked about this. We talked about it in the previous um, cycle, the other class, and I'll end with this. There's something called what's called the poor man's copyright, where you write the song and you fold it up, you put it in an envelope, and mail it to yourself. There is some benefit to doing that. But if you're going to do it, you want to, when you write that out, you write the song, you put it in the envelope, send the envelope, number one, send it back to your self-registered mail, so you have to sign for it. And it's dated. Number two, don't open it when you get it back. Instead, take the envelope, the still sealed envelope, put it in a safe deposit box or someplace safe. And that's it. The next time you should touch that envelope is if somebody says you copied your song off of their song, and you can show that their song was copyrighted, or their song was registered, or they say their song was registered or copyrighted, not registered, but their song was copyrighted on January 1st of 2020, but your song was written January 1st of 2015, or February 1st of 2015, and you have in your possession a certified letter that has never been opened, that you mailed to yourself back in 2015, you take that letter and you hand it to a judge. You take the whole envelope, you don't open it. You hand it to a judge, let the judge open it and see that it's registered, it's signed for. He opens it, he pulls the letter out, he can see that there's the piece of music in question. And that actually has some benefit in the case of a lawsuit. So it's not that you shouldn't do that, but what you should do is you should have registered your stuff anyway. So, okay, that is everything I have. Wow, that is a lot of information, and my brain is fried. So I wish we were together and you were asking questions. If you were asking questions, we'd probably still be on chapter 18. But we don't have that benefit. So be sure that you send your questions in. I'll try to find the answers for them. And get your stuff in on time. And we are 2 classes after this. So hang in there, be safe, and this too shall pass.